Hey, it's Vanessa Hardy from Long and Foster, and I wanted to talk about earnest money deposits and what happens to the buyer's earnest money deposit, in particular in a transaction that does not close. This happens often in our area. I see a lot of buyers and sellers who wind up confused, annoyed, frustrated after a contract doesn't close and there's a dispute about the deposit. So let me give you a hypothetical. Let's just set down an example. Let's say you've got a buyer and a seller. They've ratified their contract. Buyer puts a $20,000 earnest money deposit, and it's going to sit with the settlement company. Settlement company is holding $20,000 until closing. Buyer goes through their home inspection. They have their HOA docs. They've gotten their loan approved. And so maybe we're 2 weeks, maybe 10 days away from closing. And let's just say, for our hypothetical, that the buyer starts doing research on the property online, and they find out that the city or the county is going to expand the road in front of the house. It's going to be a much bigger road in the next couple of years. And the buyer says, "Oh my gosh, this is horrible. I don't want to buy this house." And let's just say that the buyer assumes that the seller surely knew about this, and the seller should have told me. So buyer doesn't feel bad about walking away because the buyer's feeling is, oh, surely the seller knew about this and just didn't tell me. And let's say the seller says, I had no idea about this road. I had no idea. I didn't keep anything from the buyer. And I want that buyer to come to closing when we are set to close 2 weeks from now. Okay, so you have a problem. Um, Often, what's going to happen is the seller is going to call their listing agent and say, I expect that buyer to be there. And if the buyer doesn't show up, they're in default, and I want to keep that $20,000 earnest money deposit. I want the settlement agent to send that earnest money deposit to me, the seller. And the listing agent is likely going to tell the seller, one, listing agent can't give legal advice. So the listing agent will likely tell the seller, you should talk to an attorney. And here's another bit of advice that the listing agent is likely going to tell that seller. There are only three ways in our area where a settlement agent who's holding that deposit, there are only three ways that that deposit can get dispersed. One is buyer and seller under written agreement. They direct the settlement agent as to where that money is going to go. That's the first one, buyer seller written agreement. The second is settlement agent says, oh my goodness, there's a dispute and I don't know what to do with this money. I'm going to send the money to the court in our jurisdiction. I'm just going to send the money to the court and everyone can just go to court and fight it out. I'm out of it. That's the second way. The third way is a court could decide, a judge could issue a ruling saying this is where that $20,000 deposit, the judge could say this is how that $20,000 deposit is going to be dispersed. Those are the only three ways. Let's go back to the first way, buyer and seller written agreement as to how that fund will be dispersed. So here's the thing, when you ratify a contract, buyer and seller, in your sales contract, it says when we close, buyer and seller both agree in writing. When we close, that $20,000 earnest money deposit, it's going to be credited to the buyer. And that's it. There is no other written agreement about what is going to happen to that deposit money. So when there's an argument and the buyer says, I'm not coming to closing, the seller can't just say on their own, I want that money. The settlement agent can't just send the money off to the seller because the settlement agent only has one written document that says at closing, buyer gets that money as a credit. So what do? If both buyer and seller agree, okay, the road's coming, it's unfortunate, let's just sign a release. Buyer and seller can just agree. We'll sign a release, $20,000 goes back to the buyer. But if you're a seller who does not want to sign that release, and maybe you're a buyer who does not want to sign the release, it means you have a fight. And what if you are a seller who needs to sell their property? Let's say that seller who has the road coming in front of the house. What if that seller, they've got a job transfer, they've got to get out of here, they've got moving vans lined up, they need to move. They don't have time for the fight. So very often what happens is that very frustrated seller will say, to heck with this. I need to move on with my life. I'm very annoyed that this happened, but I get it. I got to get my property back on the market. I need to get it sold. I'm going to have my listing agent draw up the documents. I will sign them, giving that buyer back their deposit, and let me just move on with my life. Because here is the problem. Unless the parties agree to some sort of a release, some sort of an agreement in writing after they have ratified a contract that doesn't close, the seller is stuck. Both buyer and seller still have potential legal obligations if no release is signed. So if you have a buyer who says, I want all of my money back because I think you knew about that road, and you have a seller who says, I didn't know about that road, I'm not giving you all your money back, you've got a problem, because the seller can't move on and neither can the buyer. The parties have to come to some agreement in writing or they're both kind of stuck. If the buyer wanted to, the buyer can go right down to the courthouse and file a document, a lease pendant, litigation pending. The buyer could say, I want that $20,000 back. And if you're not going to give it to me, I'm going to go to court. I'm going to start up a legal process. And now I've put a cloud on your title. So even if you have a seller that says, to heck with that buyer, I'm not signing anything to give them their money back. And I'm going to go ahead and put my property on the market and sell it to someone else. That won't work, because anyone else who looks at the title will see that the buyer, that old buyer, has a document filed. And when they do a title search on the seller's property, they're going to see that document, litigation pending. So that seller is not going to be able to issue title insurance to anybody else. The seller is stuck until they deal with that last buyer. So here's the thing. Here's the advice that I would give to people. Because our deposits, in a way, they show good faith. But if something goes wrong, they don't automatically go to a seller. And as much as this is frustrating for sellers, you do have some options. Let's go back to that number one. As long as there is something in writing, that settlement agent can disperse those funds if there is a default. So if you've got a hot property and you're a seller and you're getting multiple offers, you could definitely put something in writing that says, I want that deposit to be non-refundable. Right off the bat, in writing, before ratification, put that on paper. That's one thing you can do as a seller. And the second thing that you can do, if you're a buyer, you can use that as a way to get, a way to compete. If you're competing for a hot property and you're a buyer, make your deposit non-refundable. Put that in writing. And that way the seller knows this person is serious. They want to buy my property. They're really putting their money on the line. And for a buyer who knows that they want that property, that's a really great way to set yourself apart without adding your sale price, without increasing the sale price, to really show to the seller, I'm serious and I'm going to finish this transaction. If you've got questions about anything going on, I help buyers and sellers with complex real estate transactions all the time. Please use me as a resource.